Such a beautiful day. We have the two candidates for one Supreme Court seat. We have Judge Juras-Sandefur with the 8th Judicial District, and we have Professor Kristen Juras, who is a longtime professor at the University of Montana Law School. We will take written questions from the audience. Flag down Peter Johnson from the Tribune. He's there in the green plaid shirt. If you have any questions, and he'll pass those up here. Our candidates each have 5 minutes for an opening statement. And the first speaker, the opening statement, is Judge Juras-Sandefur.
Thank you, Rich. I am Judge Juras-Sandefur. I'm running for the open seat on the Montana Supreme Court being vacated by Justice Cotter. This is one of the most important races, if not the most important race on the ballot this year. The difference between my opponent and I can be really summed up on 3 simple points. First is there's no substitute for relevant experience. Second, the Montana Supreme Court is no place for anyone with a political, social, or other philosophical agenda. And 3, I'm trusted and supported by the people who you trust to protect you and to protect your rights in this community and in this state. In regard to the first point, people need to understand that the primary function of the Montana Supreme Court is to review to review cases that come to the Supreme Court from Montana's district courts. Those are the cases that I've been deciding day in and day out for the last 14 years. Everything from A to Z, on the criminal side, complex civil litigation, child abuse and neglect, a wide variety of other matters that come before Montana's trial courts. I've got 14 years of proven judicial experience deciding the broad scope of cases that come before the court. I'm the only candidate in this race who has judicial experience deciding these cases. In that regard, I've also sat on the Montana Supreme Court at the invite of the Chief Justice as a substitute justice on occasion. I know the job, I've done the job, and I have the qualifications to do the job. In contrast, Professor Juras has no judicial experience. She practiced law full-time at one point in her career for a while, I think between 1978 and 2000, in an office practice setting. She wasn't a courtroom lawyer trying cases in front of juries in state district court. She has no experience with criminal cases, which represent about half of the caseload of the Montana Supreme Court. There's no experience with child abuse and neglect cases, which also represent a substantial portion of the cases decided by the Supreme Court. And in regard to complex civil litigation, again, she was not a complex civil litigator. Now, do you have to be those things? No, you don't. But what the justices do is decide the broad swath of cases that come before the court. I'm the only candidate that's been deciding those cases. She will tell you that she has some sort of specialized experience. To the extent that she does, or asserts that she does, and those cases are decided in Montana's district courts, I'm the one who has the specialized experience because I've been deciding those cases in the district courts for the last 14 years. Secondly, the Montana Supreme Court is no place for anyone with a political, social, or personal agenda. I have a proven record of deciding all of these types of cases that come before Montana's courts in a fair and impartial manner. I have a reputation and a record in the legal community in the state of Montana as a highly competent, fair, and impartial judge. And win, lose, or draw, lawyers will tell you that I was not biased, I was competent, and you won't find a hint anywhere of any personal bias, agenda, or partisanship in any decision that I've ever made. In contrast, Professor Juras, over the 15 years that she's been a law professor and prior to this campaign, has taken a lot of public positions on a wide variety of issues. Those matters are out there in the public domain. I won't go through them here today. Lastly, I'm proud and honored to tell you that I am supported by the people that you trust to protect your rights in this state and in this community. I'm endorsed by every single one of Montana's retired Supreme Court justices. That represents the full scale of judicial philosophy in Montana over the last 20 years. They know the job, they've reviewed my work, most of them, and they understand what it takes to be a quality Montana Supreme Court justice. I'm endorsed and supported by Montana district judges, Montana prosecutors, Montana law enforcement officers in this community, both of the local agency officers, a wide cross-section of lawyers who you trust and support, you call on and require to represent me. You need them. I am the only qualified candidate in this race. Thank you.
Thank you, Judge Sandefur. Now, Professor Juras.
To thank the Tribune and the Great Falls Chamber of Commerce for sponsoring this event. This is a race, I agree, that is a critical race, but it's a race that falls often under the radar. It's the only statewide race that is nonpartisan. It's nonpartisan for an important reason. The court is not a legislature and doesn't make public policy, but because there's not a familiar R or a D behind the name, a lot of times people who aren't familiar with the candidates don't know very much about the candidates, so this is an opportunity for you to get to know each of us better. I believe that we're both qualified candidates. I'm glad that the electorate has two qualified candidates to choose between. We come from very different backgrounds and different perspectives. I was born and raised in Conrad, Montana, on my family's ranch. I graduated undergraduate from the University of Montana. My husband, John, and I have been married for 32 years, and we believe in diversity. We have a son who's a bobcat, a son who's a grizzly, and a son who is an orator. I went to law school at the University of Georgia in Athens and worked for firms in Atlanta and Oklahoma City before returning to my home state of Montana in 1988, where I joined the Church Harris Johnson & Williams law firm. I represented individuals, farmers, ranchers, small business owners in a wide variety of legal issues that they face on a daily basis. Contrary to what Mr. Sandefur asserted, I do have extensive experience, not only outside of the courtroom, where I have done a significant amount of drafting of contracts, formation of partnerships, tax planning, forming and dissolving entities, nonprofit organizations. I do have considerable experience inside of the courtroom as well, having been involved in both jury and non-jury trials in litigation involving will contests, in title disputes and property disputes, landlord-tenant disputes. I've handled many property tax appeals, income tax appeals, regulatory matters, disciplinary matters before regulatory boards. I've also been involved in complex litigation, including securities litigation. I do have criminal experience. I have represented criminal defendants, everything from misdemeanors to felonies, including tax fraud and securities fraud and fraud in obtaining educational assistance. I've also served as a mediator and an expert witness. Most recently, I was in the courtroom last week in a contested hearing in the 9th Judicial District. I did begin teaching law at the law school in 2000, where I have taught a wide variety of classes, including property, contracts, business law, international law, water rights law, agricultural law. While practicing, I have also always maintained a private practice and have always had a variety of litigation and other non-litigation matters. As a professor, I was awarded the Outstanding Teacher Award, a Faculty Scholarship Award, the Marjorie Hunter Brown Award for commitment and service to students. And I think if you ask any of my students, they would tell you that I never brought a philosophical agenda into the classroom, that I strive to teach students how to be good lawyers, how to be problem solvers, and how to keep politics out of the law, and that is exactly what I would do on the Montana Supreme Court. I have also been significantly involved in providing pro bono work throughout my 34-year career. In the past year, I have committed over 500 hours of pro bono work in some very difficult and complex cases, including clients with physical disabilities and mental health disabilities. A diverse court is a better court. The Montana Supreme Court has always consisted primarily of attorneys rather than sitting judges. I do think the court benefits from the experience of having a district court judge on the court, and currently we have Justice McKinnon on the court, we have Justice Jim Shea, who's a former administrative law judge, so we do have that experience on the court. What we don't have on the court is somebody with 34 years of experience representing individuals, farmers, ranchers, in the types of legal issues that they face, and that is lacking and has been lacking on the court, and it would be a gap that I would fill. I'm very committed to consistency and predictability in the law, to fairness and impartiality, and bring absolutely no agenda whatsoever to the court. Thank you.
Thank you, Professor Juras. Just like to take a moment, the fellow here in the green plaid shirt, Peter Johnson, will take your questions. If you want to write them down, then just raise your hand and he will bring those up here. Also like to introduce our expert timer, Scott Thompson, who's the Tribune City editor. He's done it right twice so far, so that's good. Good start. And then I'd like to introduce our distinguished panelists. They are closest to the ledge there is Jan Cahill, representing the Great Falls Area Chamber of Commerce, and he also happens to be the chairman of the Great Falls School Board. And we have Andrea Fisher, who is the courts, crime, and breaking news reporter for the Great Falls Tribune. Our first question is going to come from me, and it's based upon a couple of op-ed opinion pieces that we ran in the Tribune regarding both of the candidates here. They had a similar theme, which was each writer contended that the candidate was very partisan. One claimed that Professor Juras is too conservative. And we also have a question for the audience, which throws in the issue of whether the professor's Christian beliefs will have anything to do with her if she's elected to the court. And there was also the contention that Judge Sandefur is too liberal, and and he's supported by members of the bar, and the contention that that might have something to do with his suitability to serve on the court. So our first question, it'll be Judge Sandefur and then Professor Juras, would be, are you too partisan to serve on the Supreme Court?
Absolutely not. I'm not partisan. I don't know where the liberal label comes from. It comes from people tossing fruit from the other side of the aisle. I'm not sure why. I've been on the court for 14 years. I've decided every single type of case that comes down the road. Never, ever has one single case had any tinge whatsoever of any partisan leanings one way or the other. I'm not sure what type of, where I'm at on the partisan scale at any given time, and wherever I'm at, it doesn't matter. These cases are about the facts and the law, period, end of story. Now, where this is coming from is my opponent is supported by, very prominently, by people on one side of the spectrum, and those people are trying to then characterize me, not because of anything that I've done, as being from the other side of the spectrum, but because they don't like some of the people that are supporting me. And specifically, we hear all the time about the trial lawyers. The trial lawyer is this, the trial lawyer is that. I'm proud to have the support of Montana's plaintiffs' bar, a substantial portion of Montana's defense bar, criminal prosecutors, criminal defendants, practitioners. My opponent would be thrilled to have the support from the bar that I have. If she had it, she'd be here touting it. She doesn't have it. Why? Because these people know what goes on and what it takes to be in the practice of law in this state, and they know who's the most qualified person for the job. I would defy anybody to find any tinge of partisanship in anything I've done in 14 years. Thank you.
No, I am not too partisan to serve on the Montana Supreme Court. As I noted, this is the only statewide race that is nonpartisan, and that is because the court is not a legislature. I strongly believe that the three legs of our government, the judicial branch, the executive branch, and the legislative branch, each have a very important but a very separate role. And our Montana Constitution specifically states that no one branch should impinge upon the powers of another branch. Yet our Montana Supreme Court has been characterized both by authors from what one may consider the left and what one may consider the right as being an activist court that does often create new laws rather than allowing the legislature to serve that role. I come with a platform, and I'm passionate about it, that the court is a court and it is not a legislative body. Its responsibility is to protect existing constitutional rights, not to create new constitutional rights. That is reserved to the people and or the legislature through either an initiative or referendum process. And partisanship does not have a role on the court. I will fairly, impartially apply the laws adopted by the legislature, even those laws that I perhaps may not have supported or voted for if I had been a member of the legislature. Thank you.
I'm going to read the I wanted to add to that the idea that a former police officer and prosecutor and state district judge 14 years is a liberal is laughable. It's laughable. I've been called a lot of things, but never a liberal until I was in this race. And I think that people that are fair-minded need to consider the source. I have support while we're talking about partisanship from Republicans, from Democrats, and everybody in between, particularly in this community where people know me. They know I'm not a partisan, and I'm proud to have Republican support and Democratic support, and I have that kind of support across the state, except for my D-Lock. And thank you.
Okay, now we're going to turn it over to our panel, and Jan will ask the first question.
First of all, on behalf of the Great Falls Area Chamber of Commerce, thanks to both of you for running for the Montana Supreme Court. We appreciate your interest in it, and we wish you the best of luck. First question from the Montana Area Chamber of Commerce. Describe a situation where you faced an ethical dilemma, and how did you resolve that ethical dilemma?
Well, I have faced many ethical dilemmas, but one that comes to mind was when I was in-house counsel for a publicly traded corporation that was headquartered here in Great Falls, and my role as the attorney was to represent the corporation. And the corporation came under investigation for some conduct that had been undertaken by certain officers of the corporation. And that is very difficult when an attorney is put in the position of representing a corporation who acts through its officers, and those very officers were the people who extended a job offer to that young attorney. And there, in my opinion, arose some conflicts between what was in the best interest of the corporation and the best interests of those individuals. And I sought out mentoring from members of the bar. The bar has a disciplinary council and people who are available. And I knew that who I represented was the corporation. And of course, I had in the back of my mind that my mother had invested some of her funds as a shareholder of the corporation, and it was also important to do what was best, not only for the corporation, but for the interests of the shareholders. So I was able to sort that out and come to a clear understanding of whose interests I represented, and that was the corporation, and indirectly doing what was best for the shareholders, even if those interests were at times in conflict with the officers of the corporation.
Thank you, Professor. Judge Sandefur.
Montana's district judges face ethical dilemmas every day because we're elected. Unlike any other elected official in the state of Montana, executive branch or legislative branch, those officers are elected generally to represent the popular will of the people. We've chosen to elect judges in Montana, but it creates pressure on the judiciary, particularly on the district court judges who are less insulated from the public than the Supreme Court judges, to issue decisions that are not in accord with the law and the facts, but rather satisfy one segment of the public or the other. And invariably, when you issue those types of decisions, people who don't understand the process, or frankly don't care about the process because they're invested in whatever the issue is, they want to take a pot shot at you. And Montana's judges are elected to do the right thing under the law and the facts, not the popular thing. And it's awful lonely when you're wearing that robe, when you know that when you take that oath and you have to make a decision under the Constitution that is going to be a decision that is not popular to some people in the public, and you know you're going to catch some hell of it from it. But as somebody more famous than me said, at the end of their distinguished career, the things that I caught the most hell for were often the things that were the best things that I did. And that's truly the plight of a judge in Montana. There is that pressure, and that's where the rubber meets the road on your integrity, is whether or not you can look yourself in the face, withstand that, and call the case on the law and the facts, and let the chips fall where they may, regardless of whether the public or some segment of it is happy or not.
I agree that justice has to be willing to make unpopular decisions and stand on their decisions even when the media disagrees, when it's not politically correct, when it's unpopular. And I believe I have a very strong record of being able to make ethical decisions, decisions of integrity, and stand behind them even when they cause a public uproar, even when I am heavily criticized, even when a governor calls and asks that the president of the university terminate my employment with the university because of his displeasure with positions that I have taken. I understand that and am absolutely able to do that.
Thank you. We've received some really great questions from the audience, and we're sorting through them for sure. But in my own self-interest as a reporter, and one of the topics that I've put my finger on for the year with the series that I'm doing, I have to ask my drug question first. The criminal justice system is being overwhelmed by drug-related issues. What approaches will you take to tackle the drug problem that is plaguing Montana?
Judge Sandefur is first on this one.
Thank you, Andrea. The drug problem in this state, as it is around the country, is at disturbing dimensions. It permeates just about every type of criminal case, child abuse neglect case, financial stress case that comes before Montana's district court and wind their way up to the Supreme Court eventually. And the court, because it is not a policy-making body, it is not the executive branch, which is the law enforcement body, has a very limited role in solving the drug problem that we have in this state and in this country, because it's largely a public health problem. We've tried to address it as a criminal justice problem. Our jails, federal and state, are full of people on drug offenses, including people who largely who largely are people who are addicts rather than distributors and manufacturers. From the court standpoint, what we need to do, and we do, and I have done, is to hold drug dealers, drug manufacturers strictly accountable, to deal with addicts and users, particularly young people, on nonviolent offenses, to treat them from the standpoint as in accordance with what the legislature wants us to do, which is to get them treatment, get them supervision, and hopefully get them the help that they need to get back into the community. Now, with people who are multiple offenders, that's a different story. Some of those people need to go to prison. Some of them do. I sent several of them down the road to the prison this morning.
Well, this is one issue where Mr. Sandefur and I are in strong agreement. It's a problem. The judiciary alone can't solve the problem. It's going to take a legislative effort. I am very appreciative for the drug court that is here in Cascade County and other counties, which has proven successful, for the veterans courts. I think that mental health problems also go hand in hand with some of the drug problems, and these are community-wide and statewide problems that end up at the court, but have a lot of their resolution outside of the court in various programs that try to divert youth from using drugs, from providing education, rehabilitation, and all of the other things that the community, and most importantly, family, strengthening families, getting families involved to help with this problem. It is a problem, and we all need to work on it together.
But
Yes.
I would just add to that in regard to Professor Juras' comment about the mental health problem. That is also an independent but related, very serious problem in Montana's court system, which I largely lay at the feet of the legislature and in its dereliction of its duty, in my view, to provide sufficient funding and services to deal with and care appropriately for and supervise the mental health people in our society. It's atrocious due to the lack of services and structure in the community. These people fall out into the criminal justice system often. They're incarcerated. Too many of them are incarcerated. We're better than that, but we can't deal with that without the tools in the court system unless the legislature does its job.
Next question. What is your general opinion of property rights with emphasis on public access?
Of course, our Constitution, the Montana Constitution and the federal Constitution protect property rights. Property rights are important, and each and every citizen has the right to own property. In Montana, in 1985, the legislature adopted the Montana Access to Public Streams Act, and it provides access to the public to streams that are capable of recreation throughout Montana, whether or not those streams, the stream beds, are owned by the state, the larger navigable waters, or are privately owned. Most of our waters are non-navigable waters. And this legislation is a good balance between protecting property rights in that it prohibits recreationists on the streams from going above the high water mark unless necessary to portage around an artificial barrier in the water. It does very clearly on its face require the public to enter a stream from a public access site. If you want to cross private property, you need to get permission of the landowner to cross the private property. And then we've had some case law that has expanded and clarified on this legislation. For example, it's been determined that the public can access public streams through a public bridge, not a private bridge, but a public bridge, and it's right of way. So I think that the cry that we're hearing that public access is somehow in danger in Montana is not true. I think the law is settled. I think it's the responsibility of the courts to continue to apply that well-settled law. We may have various questions come up. What is the high water mark? What streams are navigable, non-navigable? But right now, the law is a good balance, and I am absolutely committed to continuing to apply those laws.
Respectfully, I disagree with Professor Juras about her at least previously published views on this point. I would at the outset commend her for a fine job in a law review article that she wrote where she surveyed the history and development of Montana stream bed access laws. What part of the controversy has been in this race is that in that same law review article, as she cataloged the ongoing development and evolution of Montana law, she characterized recent developments that are well settled as a monumental erosion of private property rights, referencing the private property right to exclude the public. Now, I absolutely agree and support the fundamental right to own private property. That's what that is a fundamental bedrock principle in our state and our federal constitutions, and it should be. But it's a different matter when it comes to public access to publicly owned stream beds or publicly accessible stream beds under the law. And I think, again, with respect, that when she made those statements in her law review article, she wasn't planning on running for office, and now is having to deal with that, which is difficult. But that's what she said at the time, and it's a matter of public record. And I think that even to the extent that she now asserts, well, that's not a big deal because it's well settled, she indicated in that same law review article that perhaps some developments in the federal case law would render those issues open to discussion. And to be fair, that case has since come down in out of the United States Supreme Court that you were referring to, and I don't know to what extent it affects it, but you did say that.
There was a monumental change in property law. Since 1889, stream beds of the smaller streams, what we call non-navigable streams, were held repeatedly by the Montana Supreme Court as private property owned by the stream bed owners. And the case law was that the stream bed owner, did I just lose sound? Yeah. Can we stop until I go? Oh, was that me?
Anybody else have questions they'd like to raise?
Okay, we're back. So I have permission to start from the top. Since statehood, 1889, the stream beds of smaller streams, non-navigable streams, have always been owned by the property owners on either side of the stream. And it was in 1984, on the Dearborn River, Mr. Curran was the landowner involved, that the Montana Supreme Court reversed all of the case law since 1889 and determined that even if private stream beds were privately owned, the public nonetheless had the right to step on those stream beds in order to recreate on the streams. That was a significant change in property law, and that was the comment that I made. There was another Montana Supreme Court in 2006 that I criticized, which allowed a prescriptive easement across private property up by Essex to access the South Fork of the Flathead River, and the statute specifically says you cannot acquire a prescriptive easement over private land to access streams, and they simply missed that statute.
Rebut. Oh, was that on the line yet? Was that your question first?
Yeah, there's
Okay.
only one rebuttal
Very
allowed.
good, I'm sorry.
Thank you. Okay, Andrea?
If you become elected, how would you treat the laws surrounding the rights of the LGBT community? Would you seek to preserve the newly gained rights or seek to restore a balance with religious rights as other states have done?
I'm sorry, Andrea, I couldn't hear your question very well.
Okay, Judge Sandefur, what would you do about the recent progress in LGBT rights, and how would you approach that on the Supreme Court?
I think the question was different.
Well,
Would you ask it again? Since it's
they
your
mapped
question?
out, it's from the audience.
After saying how would you treat the laws surrounding the rights of the LGBT community, would you seek to preserve their newly gained rights or seek to restore a balance with religious rights as has happened in other states?
The recognition of the legal legitimacy and validity and right to same-sex marriage was made recently by a United States Supreme Court decision. That now is the law of the land. That is a recognized right within the parameters of the federal decision. It is precedent, binding constitutional precedent to state and federal courts. And so absolutely, I would enforce that right as it's been defined and recognized by the United States Supreme Court. It's not the role of the state or federal court to try to restore the pre-case status quo. That case is not, I'm not sure exactly what type of case you're referring to or how that would happen, but it's not the role of the court to chip away at rights that have been recognized as federally protected rights by the United States Supreme Court.
In 2015, the United States Supreme Court did issue its ruling in the Obergefell decision that there is a fundamental right for same-sex marriage. Under the United States Constitution, the Supremacy Clause, Article 6, Clause 2, the state courts are bound to apply the federal laws, including the laws of the U.S. Supreme Court. So that decision is binding law in Montana and other states and will be applied. And there is a right to same-sex marriage in Montana as a result of that United States Supreme Court decision. But there will be cases after that decision that are going to address any conflicts that may arise between the right of a same-sex couple to be married and the exercise of free religion. And those rights, I don't think anybody can disagree, are going to come up and they may be in conflict, and we've seen those around the country. So, for example, as a judge who does not adhere to the belief from a religious perspective of same-sex marriage, will they be obligated to officiate at same-sex marriages? And we've seen the situations about cake bakers and others. So there will be cases that will decide the tension between these two rights. And the right of the freedom of religion is a very important right that also must be taken into account, and it's going to be a case-by-case situation and decision. So, for example, the federal courts and state courts have already recognized within the exercise of religious freedom the ability to what you might call discriminate. The Catholic Church, for example, is not required to hire women as priests because of well-founded religious beliefs. And you may state, well, that's discrimination against women, but it is because of the exercise of free religion, a lawful exercise of religion, and we'll see those sorts of cases arising in this context as well.
Rebuttal?
I'm not sure what the anticipated tension is, and I guess that would have to be left to an individual case as it presents to the court, whether that be a state court or a federal court. The right that has been recognized is a constitutional right under the United States Constitution. And the right to religious freedom is the exercise of religion, and free exercise of religion is a fundamental constitutional right that protects all of us from the government. It's a shield to protect us from the government sticking its nose into our religious practices and beliefs. It is not a sword that was intended to be used to discriminate against others in the exercise of their federal constitutionally protected rights. That is the state of the law.
Jan Cahill with the next question.
Montana is considered to have one of the least business-friendly Supreme Courts in the United States. What would you do to help correct that perception?
I would vote to place on the Montana Supreme Court somebody with 34 years of experience representing small business owners. The law is as diverse as medicine. It is complicated, and we need expertise from a wide variety of law, including criminal law, also including business law on the court. And that is one of the ways to improve the business legal climate in Montana. As you may know, Montana has been consistently ranked in the bottom tier of states, amongst the states in the union, for its business legal climate. And that comes from a variety of factors, including the lack of extensive business experience on the court. Another problem is that not only businesses, but all citizens need predictability and consistency in the application of the laws. Between 1990 and 2000, the Montana Supreme Court reversed itself 109 times. Since 2000, it's reversed itself another 1,000 times. And that unpredictable climate from a business perspective is a climate that doesn't entice investments in Montana. So not legislating from the bench, consistently and predictably applying the laws adopted by the legislature is one of the solutions to this problem.
I would agree with Professor Juras in regard to what the business community needs and should expect from the court system. It should expect predictable results so that lawyers can, from a proactive standpoint, counsel their business clients about how to conduct business within the parameters of the law and give them good counsel about what results might be depending upon what action that they take. On the back end of it, from the Supreme Court standpoint, when it decides, and this applies not just to business cases, it applies to every type of case in the law, the court needs to be consistent. And frankly, as a district judge, although I don't go around the state bashing the Supreme Court, I'm often frustrated by that because I don't like it when the Supreme Court tells a district judge that you got it wrong because you followed their precedent. But it does happen from time to time. What I do disagree with Professor Juras about is, again, with respect, I have a hard time with this idea that you keep telling people that you have this 34, 35 years of experience as a lawyer, practicing lawyer. You haven't been practicing law full-time since 2000. You've been a law professor. You've been of counsel with your law firm here in Great Falls. I'm not saying you haven't engaged in some practice areas, but you haven't been a full-time lawyer. And the other point, and I say that only as it relates to your assertion that you have this unique specialized experience. And the other thing I'll say about that is that to the extent that business cases are being decided in Montana's courts, those are the types of cases I've been deciding. I have a good record with business lawyers across the state.
Rebuttal.
Well, with all due respect, I have been an active lawyer even after teaching at the law school, but I also want to point out that the Montana Supreme Court, it's an appellate court. Its job isn't to run trials, but it reviews especially legal issues that are decided by the district court judges. And having taught for 16 years has actually improved my ability to sit on the Montana Supreme Court because of, as a professor, the extensive types of research that I do in analyzing legal issues and being able to break those down and teach them to students so that they can learn them. As a professor, I have written over 3 national textbooks, including textbooks in the area of business law, property law, and other sorts of law that have made me become a better writer and more capable of explaining the rules, and that is a good attribute for an appellate judge to have.
Okay, thank you very much. We're going to take a 5-minute intermission, and then we'll be back right at 7 o'clock. If you'd like some water, there's some right up front here. Thank you. Okay, here we go. Janet Cahill will ask the next question from our panel.
The Montana Constitution, Article 10, Section 6, prohibits state money to aid any school controlled in whole or in part by any church, sect, or denomination. What is your view on the use of public funds for parochial schools?
My view is just as it's stated in the Constitution. That's the law, that's the will of the people, as embodied in the Constitution as of 1972. And to the extent that that comes before the court in some fashion, it's the duty of the court to enforce the Constitution as written and within the scope of the intent of the 1972 Constitutional Convention from which it derives.
Yeah, the Constitution clearly prevents direct support from the state government to parochial schools. There is a case that is pending before the Montana Supreme Court, and it involves what would be considered an indirect, whether an indirect appropriation is lawful. And that relates to a 2015 bill that was passed by the Montana legislature that allows taxpayers to deduct for Montana income tax purposes funds that they set aside for scholarships to students, including students attending parochial schools. And as judicial candidates, our judicial code of ethics prohibits us from predicting how we would rule in any pending cases or cases that might come before the court. So that's an issue that's pending before the court.
And I would agree with Professor Juras on that point. It would be improper for us to comment on that application of the Constitution to a particular fact pattern.
Andrea.
Which United States Supreme Court case do you most disagree with?
Is this for me? Who starts?
Professor Juras goes first here.
The Dred Scott decisions, the racial decisions that said that upheld separate as equal in race relations.
Juras-Sandefur.
I would agree that Dred Scott is the low point of jurisprudence in this country. To those of you who aren't real familiar with it, the upshot of it was that the United States Supreme Court, in the run-up to the Civil War, determined that slaves were property, not people entitled to rights. And an offshoot of that was this Plessy versus Ferguson case that Professor Juras refers to. And I also have an issue with the civil rights cases, which is a post-Civil War case where the court caved in politically to the South and basically gutted the Privileges and Immunities Clause of the United States Constitution.
Would you care for a rebuttal? Jan.
How important is it to have presided over criminal trials as a Supreme Court justice?
Judge Sandefur goes first on this.
I think it's very critical and very important. The criminal justice system turns on a number of very fundamental bedrock constitutional principles, not to mention issues and applications of state criminal law and procedure. And if you don't have a working understanding of what goes on in the district courts, how these issues come into the court, what the nuances of these factual records are, all you can do then is look at the dry record on appeal. It does not serve Montanans, it does not serve criminal defendants, and it certainly does not serve Montana's law enforcement community. This is an area where there's a fundamental difference between Professor Juras and I. And with respect, I want to challenge her on a statement she made earlier that today she says that she has some substantial criminal justice experience representing criminal defendants and prosecuting cases. At the ACLU forum in Missoula about a year ago, you indicated something to the effect that you didn't have any criminal experience, but that other people on the Supreme Court did, and so you could rely on them. That's just wrong.
At the ACLU forum, I did acknowledge that I certainly do not have the criminal experience that Judge Sandefur has, but I do not recall that I said I have no criminal experience. I do have criminal experience, including misdemeanors, including felonies, including federal criminal law cases, including securities fraud and tax fraud. But to the larger question, when I first came to Montana in 1988, there wasn't a single district court judge on the Montana Supreme Court. It is not common for the court to be comprised of district court judges, and it's absolutely not a requirement that a Montana Supreme Court justice have prior district court judge experience. Is it important that somebody have extensive criminal experience on the court? Absolutely. And we do have attorneys currently on the court, including Justice McKinnon, who has presided over criminal trials, including former county attorneys, including former prosecuting attorneys. So we have at least 4 justices on the court today with a strong criminal background. But criminal cases consist of approximately 20% of the district court caseload across the districts and approximately 40% of the Montana Supreme Court caseload. That means that 60% of the cases are civil cases that include dissolutions, that include business law, contract disputes, property disputes, and non-criminal matters. It is equally important to have justices on the court with extensive experience in those areas, and there is, in my opinion, a lack of that extensive experience on the court today, and it's a gap that I am passionate about filling.
First of all, the criminal cases represent almost half of the criminal caseload of the Supreme Court. Professor Juras is right that there's another substantial portion of cases that the court deals with. The problem with this issue for her is, in my view, respectfully, is that I am the candidate who has broad and extensive experience with these criminal cases, with these civil cases that work their way up to Montana Supreme Court from Montana's district courts. And I am known around the state of Montana, on the Supreme Court, and in Montana's legal community as a highly, highly competent state district judge, extensively experienced across the entire spectrum of cases that come before Montana's district courts and the Supreme Court.
Okay, we're going to do 2 questions from the audience. First question deals with Professor Juras. You brought up the instance where the governor asked for your termination, and a couple people in the audience would like you to explain what happened and your position and all that, circumstances of that. And then Judge Sandefur can comment on that if he cares to. Thank you.
Well, if you don't mind, Mr. Blewett said that I had said that the Montana Supreme Court reversed itself 1,000 times between 1990 and 2000. And I misspoke. I meant to say 100. If I didn't say 100, it's 100 times, and that's in an article that's written by Jeff Rams, a colleague of mine at the University of Montana School of Law, and Rob Mickelson did a similar study after 2000. So with regard, in 2012, I prepared a report for the interim committee, a legislative committee on revenue and transportation that addressed the area of centrally assessed property, which probably only a professor would get excited about doing a study on that sort of a topic. And I compared Montana's property tax system to surrounding states, and in my report, I, in many ways, approved what the Montana Department of Revenue was doing in that area, but also criticized some of its revenue rulings as not being consistent with the statute. In particular, it was my opinion that one of their regulations taxed intangible property, which is specifically prohibited to be taxed in Montana. And by the way, about 18 months later, the Montana Supreme Court, in a decision authored by Justice Sweet, agreed with me and struck down that regulation as being beyond the statute and unconstitutional because it didn't adhere to the statute. My report was never, Governor Schweitzer was upset with my report, and he had called the president of the university and asked for my resignation, and of course the president of the university did not ask me to resign. I maintained my job.
Judge Sandefur?
The only thing I would add to that is that I with respect to Professor Juras, have no doubt that the governor disagreed with the view that I think it was Charter Communications, if I recall correctly, wasn't being taxed properly. But I think that my understanding of public record on this is that the governor was of the view that Professor Juras had not sufficiently represented to the legislature in that paper, that this was her private view rather than a view taken under the auspices of her employment by the University of Montana. Whether that was true or not, I have no idea, and I have no comment on that, to be fair.
And it's in the public records. My testimony is recorded, and the very first words out of my mouth when I gave my report was, because it did state on the face of the report that Kristen Juras, Associate Professor at the University of Montana School of Law, the very first words out of my mouth were that although I am an Associate Professor, these views are my own views and in no way represent the views of the university.
Next question from the audience. This is a question for Judge Sandefur, and Professor Juras is welcome to comment on it as well. How many of your judgments have been overturned by the Montana Supreme Court?
You know, I couldn't tell you. A very small number in relation to the number of cases I've decided over the years. I have a reversal rate that is among the lower in the state across Montana's judges. But the reversal rate, unless you're being reversed frequently, really doesn't mean a whole lot, because there's two types of cases that get reversed by the Supreme Court. Of course, this is from the perspective of a district judge, so take it with a grain of salt as you see fit. That some of them, you didn't get it wrong. They just got the last word, or they had the last word, they saw it differently, and that's how it works. And on occasion, they may find something that although you thought you had it right, you didn't. And that happens, and judges are people too. But I'm very proud of my reversal rate. I wish I could tell you the number in relation to the total number of cases that I've decided. It's also misrepresentative because of all the number of cases that I've decided that aren't appealed, because the lawyers know that there aren't appealable issues there, and they're not going to waste their clients' money on that, because the decision that I've made is bulletproof and is going to stand up on appeal.
And I just looked up some statistics today, and the Montana Supreme Court, as an appellate court, only reverses 1/3 of the district court decisions. But this is a good opportunity to just address once again the differences between trial courts and the Montana Supreme Court, which is an appellate court. And one of the places that the Montana Supreme Court always starts when it begins its decisions is what us attorneys call the standard of review. And with regard to certain rulings, such as evidentiary rulings and procedural rulings, it's an arbitrary and capricious review. They generally defer to and should defer to the trial judges who are in the courtroom hearing the trial and hearing the evidence. Where the Supreme Court does what we call a de novo review, and they look afresh without deferring one way or the other to the trial court, is on those certain legal issues that may be raised during the trial, such as, for example, whether a statute is constitutional or unconstitutional. So there is a difference between trial judges and appellate court judges, and that's one thing that voters need to take into account when they vote at this election.
And I would disagree with Professor Juras to a point. Is the function of the trial court different than the function of the appellate court? Of course it is. But the legal analysis, the legal work is the same. Because what they're doing is determining whether I applied the law correctly or I determined what the law was correctly. And that's precisely, at the end of the day, what the Supreme Court does. And it's precisely what I do in the first instance and every other district judge does in this state. And this idea that it's not advantageous to have a trial judge on the Montana Supreme Court is malarkey. Federal judges come from the federal bench. That's how they get there. They generally don't pull them out of law offices.
What has been your most satisfying courtroom or trial experience?
Professor Juras goes first.
In the past year, I represented a client who had some mental and other disabilities, and she had not been able to see her son, had been deprived of visitation and other rights to her son for a period of almost 3 years. And these sorts of cases are very difficult to take on a pro bono basis. I fortunately was in a situation where I could dedicate, it literally took hundreds of hours of time, because at that time I was not teaching, I had moved in with and was caring for my elderly father in Conrad. And as a result of many hearings, we were able to reestablish visitation between this mother and her child. We started slow and then increased, and I'm happy to report today that they have a good and a strong relationship.
It's too difficult for me to isolate any particular best moment in the courtroom because of the broad number of cases that I decide, and other judges decide too, that have fundamental impacts on people's lives. Every single case that comes into court that is decided by the court or a jury involves the most important matters of life, liberty, children, property, and every other aspect of our lives. People are in distress when they come into the courtroom. Some of them have been injured terribly. Some of them have been ruined financially. Some of them have been abused. Some of them have been cheated out of their inheritance of the family farm or ranch, or pressured out of it by their siblings who turned against them after their parents died. They're just every day. Some fine moments are just when criminal defendants who've had a terrible time, particularly drug defendants, who make it through probation, who complete the drug treatment court, and get their life turned around. I'd probably have to say as a category They're the people, criminal defendants in youth court, which are youthful criminal defenders who you felt terribly conflicted about having to send that person to prison, and you think that they just despise you, and you run into them or their mother on the street years later, and they say, "Judge, I hated you at the time, but you changed my life. That was the best thing you could have did for me. I'm glad you did it."
That's the end of the question and answer portion of our program. We're going to end with closing statements of 4 minutes each, and Professor Juras will start.
Well, once again, I thank you all for taking the time to be here and listen to us. I thank you for the Tribune, the Chamber, and the media that are here and reporting this, because it is, in fact, a very important race, a critical race. I believe that the electorate is fortunate to have two qualified candidates, and there is a difference between our backgrounds, and your decision is to decide what, at this particular point in time, does the Montana Supreme Court need to best serve the citizens of Montana. Currently, there already is, and I agree that having a district court judge on the court is absolutely good for the Montana Supreme Court. I was happy when Justice Warner was one of the first when I was practicing to be elected, and now we have Justice McKinnon and Justice Shea. But the court does need to have a diversity of experience. We also have a former county attorney, former county prosecutor, former attorney general on the court, two former legislators, so it's interesting to have that perspective of former, what we call plaintiff's attorney. But one thing that is lacking and has been lacking for years is an attorney with the experience of being in the trenches day in and day out with individuals, farmers, ranchers, small business owners. And there is a difference when you're representing somebody such as one of my clients, I'll call Mrs. P. When the government has told her that she's not entitled to be repaid $35,000 that she had loaned to her disabled son. And she, going up against the government can be tough. They seem to have a limitless pocketbook, limitless resources, and to have the perspective of representing clients in those situations is an important perspective to bring to the Montana Supreme Court. The perspective of protecting property, of dealing with employment issues and contract issues that do take up a lot of the court's time. I believe that is why I, at this particular point in time, am the best candidate for the Montana Supreme Court, and I would truly appreciate your vote. Thank you.
Thank you, Professor. Judge Sandefur.
I'll just end where I started. There is no substitute for relevant experience. I have it. Respectfully, Professor Juras does not. Talk to lawyers in your community. These aren't the so-called trial lawyers. These aren't bad people. They're people, they're your neighbors. They're Main Street businesses. They're the people that you call when you need help in the legal system, whether they're defending you, whether they're representing you. Talk to law enforcement officers. Talk to judges. Talk to current and former members of the Montana Supreme Court. You will find that I am the consensus most qualified candidate. I want to apologize to Ms. Juras here earlier. I didn't mean to create the impression that I don't think she's a quality person or a quality lawyer. That's wrong, I do. So if I gave that representation, I want you to understand I don't think that. I just don't think she's in the same class as I am as far as relevant qualifications. You need to talk to these people. People like you, most of you who aren't lawyers, who aren't in the legal system, really have a hard time trying to understand A, what the Supreme Court does, and B, how do I distinguish who is the most qualified candidate? Check with those people that do know and that you trust to know. They will tell you that's B. I need your vote, I need your support, and those of you that are here in Great Falls and to the people who are out there that this is reported to in the Great Falls community, you know me, you know what I've done in this community, you know what I've been, you know what I've not been. I've been your judge. I stand for the law, period. I am the most qualified candidate. I need your vote, and I need you to tell people around the state, because they don't know who either one of us are. Who are these people? The people here in the Great Falls, Central Montana do know, and they know that I am the most qualified candidate. Please get out and vote. I'd appreciate your vote. Thank you very much.
So let's hear it once again for our distinguished candidates. Thank you, timekeeper. Thanks for coming. Don't forget to vote on November 8th.